Good afternoon, everybody. Welcome to this panel, which is organized by the European Data Protection Supervisor. And our subject is called A Global Perspective on the Privacy Challenges of Artificial Intelligence. And my name is Achim Klabunde. I'm Technology Advisor at the EDPS. And I'm really happy to have a panel here which represents 3 continents. To my left is Professor Christiane Wendehorst. She is teaching law at the University of Vienna, and she's president of the European Law Institute. And she is much more known for a task which she performed recently for the German government as one of the 2 chairs of the Data Ethics Commission, which published its report a few months ago. And since yesterday, as I learned, also the English version of the full report is available on the internet. Left of Christiane Wendehorst is Marc Rotenberg, which I think doesn't really need any introduction in this conference. He's a pillar of privacy and data protection in the United States, founder, CEO, and president of EPIC, and has worked for privacy in so many important ways and very successfully. Next to Marc is Julia Powles. She's a researcher and publisher who has researched and published about privacy and data protection related and digital economies' impact on society and rights in the UK, in the US, in Europe, and now in Australia. She is a professor at the University of Western Australia in Perth. And last but not least, another European speaker, Bertrand Pailhes. He's the Director of Innovation and Technology at CNIL, the French Data Protection Authority. And this role, of course, he is in charge of the French data protection activities regarding artificial intelligence. But before that, he had an important role in the development of the French artificial intelligence strategy for across policy domains for the entire country. And Bertrand is an engineer by education. And to enter into our discussion, I would like to ask Bertrand, as the first speaker, to explain a bit on what he found as the French perspective, in this case, on the risks, but also on potential benefits of artificial intelligence, which would play a role for the policy and regulatory treatment of this development. Bertrand, please.
Thank you, Achim. Thank you, everyone, for welcoming us today. As always, AI is a technology. In the beginning, it's just a technology. So as every technology, it's neutral, and it's the effect that it will have really depend on the framework that we want it to be used in. So, and I think it's what has been seen by many countries and governments is that as AI is a transformative technology that is affecting every aspect of the economy and the society, they need to have some strategy, and we need to make sure that this technology is beneficial for the society as a whole. And of course, I will probably focus right now on the positive aspects of AI, because I think we will discuss a lot about the risk afterwards. But we see obviously a lot of positive aspects. The main use case is health, where we expect a lot of positive outcomes from the diagnosis to the treatment with AI, with a lot more performing algorithm for these different steps in health. We also can have aspects on the society, on the work automation, how AI can help workers to avoid to do repetitive tasks, to have work that is painful as of today. And it's also, and something that has been very important for every country, it's also a matter of competitiveness, and it's we all feel that AI will be a key factor of competitiveness for the companies, and in a global competition where a lot of countries are struggling with each other. So that's basically what was in the French strategy. That's why I think governments are putting up some strategies. We expect to have positive outcomes in terms of value chain, having actors that are able to be performant and to create value in the countries. But also, and I think it was quite important in Europe and in France in particular, the public actions aims at developing an ethical model of AI. So when you said that, you haven't said a lot, but I think this is what Europe and France within Europe are trying to differentiate with other continents, is to put in AI development, AI design, some ethical values. And perhaps the last goal that we can expect is some kind of sovereignty. And if I take the French plan, there is an important element of the plan that is concerning defense, for instance, and it's also an aspect that is important for our societies as well.
Thank you very much, Bertrand. And I think we continue right away with another national inquiry into AI and related developments. And I would ask Christiane to talk about the German committee.
Yeah, thank you so much. And first of all, thanks to the EDPS for inviting me. It's really a great pleasure to be here. So where to start? Maybe I should start by saying that the German Data Ethics Commission was a little bit critical of the term AI as such and the concept. So why? Because the ethical issues we identified did not seem to, or relate on a particular technology being qualified as AI. At least not if you take the term in the more narrow sense, in which some people use it, like it needs to have to do something with self-learning capacities and all the rest of it. We saw many of the ethical issues that do arise in this context to be very similar to the ethical issues that arise with more sophisticated algorithmic systems in general, even if they are rule-based, even if they're quite traditional. So this is why we don't use the term AI a lot. We do use it here and there. It's a buzzword which you can't avoid when you're active in that area. But we, by and large, try to use the term algorithmic system in order to demonstrate that we see this as a wider problem. Needless to say, there are some specificities about what is often called AI in the narrower sense, but we see it more as a gradual problem. Then it's not, entirely different set of ethical issues that arrive. Of course, if you use the term AI in a broader sense, and I think that's what's happening in particular in Brussels these days, is if you take AI as a kind of synonym for all sophisticated digital stuff that's not blockchain, because blockchain is just the other buzzword in that area, then of course, it makes much more sense. But maybe let's not focus too much on those concepts. So just to say that we don't use the term AI a lot, we use the term algorithmic system. And maybe just also to highlight that the approach we took was not just, seeing risks and dangers and so on. We are very fond of technology. We see the opportunities. We see the huge benefits it has or may have for our societies, for the environment, for individuals, particularly in healthcare and similar areas. But we also see that there may be problems and that we may have to address these problems. Now, when it comes to the broader sense of AI, if you like, or the broader notion of algorithmic systems, what we did in our report is something for which we have been criticized, but at the end of the day, that's what we came up with, is that we divided the issues that arise into two big clusters. So one cluster being what we call the data perspective. So that has to do with the origin of data and possible effects which algorithmic systems and data processing has on the data subjects and other people who contributed to the generation of data. And the other perspective is what we call the algorithm perspective. This is about system design and the effects which the system has on individuals and society. And the difference is that the people affected do not need to be the data subjects. They can be people that are not at all related with the input data used. And maybe I can illustrate the difference when we take the example of discrimination. So the problem of discrimination arises in both clusters. So we may have issues of discrimination when a particular data subject, for example, is confronted with personal pricing. I may have to pay a higher price because my personal input data, say I'm female, say I'm over 50, I live in a particular street, or God knows what much more sophisticated elements of my personal profile. So this is a problem of discrimination that has to do with the input data fed into the algorithmic system. But I may also face issues of discrimination of a different type, issues of discrimination that result from the training data used, from the bias in the training data used to train the algorithmic system, because these data fed into the system reflect biases and prejudices we see in our society. And so these biases and prejudices kind of translated into the algorithms. And so this is why I am suddenly confronted again with an issue of discrimination. And we looked at issues in both columns, like if you like to say it like that. Of course, we also looked into issues of data protection when it comes to training AI as such. So we all know that there are specific challenges, specific data protection issues when it comes to training AI, issues about data minimization, purpose limitation, data protection by design, and all the rest of it. So also there we came up with a set of conclusions. So by and large, you know, we see the issue arising in two dimensions. There are two clusters of issues that need to be addressed, and this is how we approached it.
Oh, thank you. I was so fascinated. I thought it should be more. You have mentioned one example of risk discrimination, and I think we have, in a couple of years ago, we saw a lot of discussion on AI and discrimination caused by practical AI systems. And as most of that was reported from the United States, I would like to ask Marc to lead us a bit on his perspective and the concrete experiences and actions of EPIC in this respect.
Well, thank you very much. I'm actually planning in our subsequent rounds to talk both about the policy frameworks and also the cases that EPIC has brought over the past year concerning AI, and I think they're significant. But I thought for the opening round I would try to follow Bertrand's lead, be positive about the technology. There's plenty of time, I think, for the negative. And also say that actually before I entered the privacy field, and even before I became a lawyer, which I have to explain is almost a residency requirement if you want to live in Washington, D.C., you're pretty much expected to be a lawyer. So to satisfy my residency requirement, I went to law school. But before that, I was actually in the computer science field working on AI and game heuristics, backgammon and chess. This was a long time ago. We had kerosene lighting. But the point I wanted to make is that in that era, when we talked about AI systems, we were really talking about rule-based expert systems that were designed by people who were very knowledgeable. Maybe they were doctors, maybe they were chess grandmasters. They would describe through a decision tree a series of choices. You could automate the decision by assigning weights to certain factors, and you would walk through the decision tree and produce an outcome. And if you didn't like the outcome, you could actually change the weightings for your factors and produce better outcomes. And there was quite a bit of this that was taking place in the 1980s in chess and medical diagnostics and other fields as well. There was, to be sure, over the last 10 years or so, a dramatic transformation in what we had called AI from rule-based expert systems to machine learning, which just relied on tremendous amounts of data and systems that, in effect, had the ability to find patterns that people probably would not find and extract from those patterns better outcomes than the rule-based systems had produced. And a fascinating example of this occurred in the chess field in the past year when a program called AlphaZero beat the world reigning chess program called Stockfish. Now, Stockfish is the old-style expert system. To be sure, it could beat any chess grandmaster world champion in the world. But along came this new program, which really had no interest in the expertise of chess grandmasters, simply wanted to know what the rules were, and said, in effect, oh, okay, thank you for explaining the rules. Now let me play about 50 million games against myself, and I'll get back to you. And that's pretty much what happened. AlphaZero came back, played Stockfish, and defeated it soundly. And this is where it got interesting, by the way, because people actually started to look at these games. These were actually better moves than the rule-based expert system had produced. The former world chess champion, Garry Kasparov, wrote a great article, by the way, in Science magazine, where he said that he was actually quite heartened to see this very human attacking style that AlphaZero had adopted. Because he said, frankly, that's how I like to play chess, and it's nice to see the best machine in the world play that way as well. So the reason I tell you this story is, I think, to be sure, when we're talking about AI in our current era, we are going to have new insights. I think, there will be advances in innovation. I think this is very exciting. I'm a big believer, by the way, in the use of AI to better understand climate change. I think this is one of those domains where we have a tremendous amount of data. I don't think we actually fully understand the significance of the data that we have. And my view is that any research initiative that can help us get a better handle on what may be the greatest challenge we face today should be encouraged. And I don't want anyone to say that, privacy advocates are standing in the way of that, because we're not. But I will say, and this is where I'll stop, I do think when we talk about personal data in the machine learning context, then we need to take a big pause. I think we need to fully understand that unlike expert systems, there is an opacity, a lack of accountability, a lack of provability, a lack of replicability, finally got that word right, associated with machine learning that is of particular concern when decisions are made about people. And when these techniques are used for employment, for criminal justice, for education, I think we all need to pause and make sure we fully understand what the consequences will be. And I'll come back. Thank you.
Thank you very much, Marc, and thank you for this very good explanation of the limits and the context of artificial intelligence. Julia, the artificial intelligence comes on top of the current system of digital economy and digital technology that we have. And there's a lot of concern about distortions in society and economy due to the concentration of power through digital technology. And you have looked at this in three different economies. And what is your conclusions from your observations in this field?
Thanks very much. Well, I might pick up a bit where Marc left off. I think the reason you were sort of asking us, Achim, why we need to regulate AI in particular, building on the existing challenges in the digital economy, and particularly why we might need to regulate it globally. And I think there's a real reason that we need to regulate it, and then there's a secondary reason that comes from our failure to address the real reason. So the real reason is that it imposes, I think, a dramatic acceleration on the conditions of a digital extractive industry that is untrammeled and without constraint. But the secondary reason that that's a problem is that every country envisages that it will be the beneficiary of that untrammeled extraction. And that conceit is particularly apparent when you move to a country like Australia. I think the US can get away with the conceit just, the UK perhaps, and Australia really not. But its AI regulation model looks very similar to a country that is a net tech exporter, and it is sitting in a part of the world that is tech importing and should be providing a model, in my view, to countries in the region that are between a US vision of technology and a Chinese vision of technology. So the conceit, I think, avoids us dealing with that real problem, which is that the promises of AI, I think, are largely unproven. The benefits are the risks are quite clear. But because of the promise of this sort of competitive, don't want to miss out, we've got to get ahead on jobs and growth, there's great ignorance, I think, of the actual risks that we face. So what opportunities that reveals, I think, are that a particular attention in countries that are tech importers to the risks would be really beneficial. And I've been trying to advocate in Australia, in a place where we have now a great digital ethics framework, an AI growth plan, that you could couple that with an actually progressive model of regulation for the risks of AI. And I think I've studied a lot in the AI and health domain, and I think it's absolutely negligent for a country not to match the same way that it regulates pharmaceuticals, the same way it regulates genomics, to also look at how machine learning systems in the health sector are really imposing quite, as Marc said, opaque and poorly distributed outcomes for individuals, and there's no reason we can't look at that further. I think if we were braver about that challenge that some countries are tech importers, you might also look at the particular way, I think the promise of the benefits in health, the benefits in environment, the benefits in labour are all there, and I find a sort of absence of evidence largely in how those are assessed. But you could impose some conditions when you claim, for example, that a system is to have great benefits for the environment. What is the actual computational cost of training that system, deploying that system? In a country like Australia, for example, if you're driving a truck across the vast country that is Australia, and you're at all times computing in real time the environment around you, requiring connectivity in an otherwise poorly connected country, what is that cost and how does it compare to a person in a truck? So I guess overall, I think there's such an opportunity for evidence in this space of great promise, and as Christiane said, it is a land where all technologies bar blockchain are considered AI now, and so it's a great fantasy land of promise, and I think that the real world of risk would be good to put front and centre, and that I think it would be particularly beneficial in countries where tech is being exported to look at tech importing nations as sites of regulatory innovation and to support a kind of dynamic ecosystem that reflects that difference.
Thank you. Thank you very much, Julia. I think we really should move on to what we want to achieve in terms of the objectives of any intervention, regulatory or otherwise. And here I would like to ask Marc to start the discussion on what he would see, and also in the coalitions in which he works, as the targets of the intervention.
Right, thank you. So I wrote a book a few years ago titled Privacy in the Modern Age, The Search for Solutions. And the premise was that we tend to talk about these problems as worried or concerned or in sort of a deterministic fashion. This is going to happen and we'll have to live with it. And the premise of this collection essentially rejects that world view. It says we have a challenge in front of us, we need to understand it, we need to reason, and we need to have solutions. And that's my view with regard to the use of AI techniques, in particular as applied to people. And so we've done several things over the last few years to try to promote constructive solutions to these challenges. We worked with the OECD AI expert group to create a policy framework that has now been adopted by the OECD member nations and the G20. It is frankly a good starting point. It talks about rule of law, democratic institutions, transparency, accountability, and fairness, all fine principles. A lot of principles are missing. And the big open question, of course, is implementation, because anyone can have, principles. What will it mean in practice? But I think it's significant. The second thing we did, working with experts and human rights groups, and you can find this online, was to create really a declaration. Lorraine Kisselberg is here, and she helped put this together, called the Universal Guidelines for AI. And this is frankly a more dramatic statement. It sets out certain red lines. For example, it says that governments simply should not score their citizens. This is a form of stigma when you assign to someone essentially a negative rating in their interactions with others. This is pernicious practice, and in our view, it should not be allowed. So I would encourage you to look at the universal guidelines, and if you support them, there's the opportunity to endorse them, and we would welcome your support. But I think the third point about what to do, recognizing the complexity of the topic and that we all have different solutions. I look forward to reading your paper. We decided to publish the first reference book on AI policy. Now, I apologize, I couldn't bring enough copies for everyone, but this is the reason I left those postcards. So this book actually contains the recommendation of the high-level expert group. It contains the Council of Europe recommendation. There are the corporate principles, Google, Microsoft, OECD, our universal guidelines. And our aim is to start a policy discussion in answer to your question as to how to regulate AI. And I will say, I think there's genuine urgency here. I mean, technologies have their own dynamic. And this particular technology has a dynamic that's genuinely exponential, and it has to do with the nature of machine learning. Data loves data, and the more data that is gathered, the more applications that will be found. So I hope this is useful for people, but as I said, I think we'll talk more about next steps. Thank you.
Thank you very much, Marc. Christiane, you have looked in, of course, developing advice for the German government and for the politics in general to what should be done in not only in the field of artificial intelligence or algorithmic systems, but in a wider spectrum. So what would your recommendations be in terms of the objectives which should be achieved?
Well, as to the objectives to be achieved, I think they're not so different from the objectives we would have formulated like 10 or 20 years ago. So we want to shape our future in a way that, it's an environment and a society that's worth living in. We want to shape our common future in a way that we feel good with, we feel comfortable with handing this future over to our children and grandchildren. And I think the ethical values that should be guiding also our handling of AI and big data are not so different from the ethical values we would have come up with some time ago or have come up with maybe even centuries ago. So this is why the Data Ethics Commission came up with very traditional ethical values at the top level, like human dignity, autonomy, and so on and so forth. The problem with doing that, with formulating the objectives at this level of abstraction, is of course that it doesn't tell you very much about what precisely should be done by policymakers. So you need to get down from this top level, from these top level objectives to something more concrete. And there I think what is really essential is that we realize that AI and data is something that is changing all segments of our life. And this is why we need to rethink all contexts and rethink the way we govern these contexts and how these contexts are also regulated, like the consumer context, the family context, the media context. So we need to rethink all these areas, all these sectors, and ask the question, are the government's features we have in place, be they of a legal kind, be they educational, be they technological, are they fit to meet the challenges? And this is where I see that we are maybe not delivering fast enough. I see us being fixated about AI having to be trustworthy, human-centric, and so on and so forth. But we are not delivering fast enough on what it really means on the ground. What does it really mean for insurance contracts? What does it really mean for personal pricing? What does it really mean for profiling? What does it really mean for data commerce and so on? And this is why I believe we need to really tackle all these individual questions on the ground. We tried to address a few of these issues that arise on the ground in the work of the Data Ethics Commission. For example, when it comes to profiling, we developed a whole list of factors which we believe need to be fulfilled in order to make profiling ethically sound. So we believe that there should be absolute limits on profiling, when it comes both to the data that may be used and when it comes to the purposes for which those data may be used. For example, we do not believe it's okay to use data which you scrape from some social media profiles and which concern the most intimate parts of your private life, and to use them when it's about, assessing job applications. We don't believe it's okay to use, the data of children, which is already recognized in many documents, but still it's not the reality. We don't think it's okay to use emotion recognition software to, check out all your vulnerabilities and then use that for just maximizing profit. We simply don't think it's okay. And we fully agree with what you just said, that governments should not score their citizens. Maybe one of those absolute limits we don't simply want to see overstepped. So there should be absolute limits. And then there's a whole list of criteria which we also formulated when it comes to the admissibility of profiling. We also formulated a list of criteria we believe need to be fulfilled when it comes to personalized risk assessment. For example, that the data used for personalized risk assessment, like with all these black box insurance schemes, that they must not, take any data that come from the core of your private life. So it must not affect, the most intimate areas of the way you lead your life. There must be, certain technical safeguards in place. There must be transparency. There must not be any implications for relatives. We said there must be a maximum price difference between the personalized rate and the non-personalized rate. We also looked at discrimination. So, we all believe, okay, discrimination has been dealt with. We have this anti-discrimination legislation. But does that really meet the challenges of the digital age? are these criteria listed, like gender, age, ethnic origin, and so on, are they really the only crucial points that matter when it comes to discrimination in the digital age? Or is it not that I may be discriminated against because of my emotions, because of the street I live in, all sorts of things, maybe because I have exercised my data subjects' rights in the past? So all these are factors that may influence the way I am treated, for example, in the context of personal pricing and other algorithmic decision-making schemes. So we looked at all these things in more detail, and I think that's absolutely crucial, that we don't just look at the top level and talk about algorithmic oversight and all the rest of it, but that we look at the stuff at ground level, because at the end of the day, algorithmic oversight works only when authorities, for example, know what they should be looking for. So there needs to be substantive rules in place that tell authorities what is okay and what is not okay.
Thank you. Thank you. This was already going very deep in what we would come back to later. But I would now ask Bertrand whether this German perspective and the French perspective with respect what the politics should achieve are matching, or where are the commonalities and where are the differences? What would you say?
Thank you. I completely agree about the fact that we need to have more detailed assessments of the benefits and the risk of AI in each context. I think in the end, coming back to the main goal of this technology, and I think the idea is to improve the lives of people or the works of people. I've seen AI that help people to not touch garbage, for instance, because a robot can do that, or in health, once again, for nurses to help them focus on their work. I think all this is positive, but requires a balance that must be made in the context. And I'm strongly convinced that what we've heard in Western countries, but in Europe in particular, in the last years is a strong support to the defense of fundamental rights, and GDPR is one of the tools that have been quite heavily supported politically, and even though it has been fought by a lot of people, I think it resonates with the society's will. But in the end, if you have a sick child, or if you have another situation, maybe you would want to process more data, to do more information, if it helps to achieve another goal that is as important as you are. So we need to do that. We need to have this assessment, context-based assessments on that. We have tools in the GDPR that are based on that, where you need to do some balances. I think in this text there's a lot of balances to make. And we need to move from 2 years ago, the CNIL made a report on algorithm in general. So as Christiane said, it's more relevant than AI, and they came out with 2 principles that were vigilance and loyalty, which is very high-level principles. And I think we're now at the phase where everybody knows that we need to be vigilant and we need to be loyal. We need to include some kind of fairness in our algorithmic system. But I think what we want to give is to give some analysis grid that helps companies and individuals to really assess on a case-by-case basis how this AI system can improve my life or improve my system, and how I can balance that with other typically fundamental rights.
Thank you very much, Bertrand. Julia, what would you think in a global perspective, or like a 3-continent perspective? Would you see any common objectives that should be achieved or aimed for by political initiatives?
Yeah, well, I'm very heartened to hear Marc and Christiane speak of red lines and of what's not okay. And if I could urge everyone to think of a goal for 2020, it'd be to really consider and to amplify and articulate red lines, because as Bertrand just said, there's so much high-level principle, and if we as experts can't consolidate around some things that are not okay, then everything is floating, I think, without any foundation. It is also interesting that ethics and guidelines are the site of the protections, the articulation of what is and isn't okay. And I think it's worth considering why ethics is that site and law isn't. It's quite depressing that much of the legal innovation is reinventing base protections of due process, natural justice and other protections. The debate over explainability I find infuriating on that front, that we are really at the base level of being able to make decisions about people and tell them why. And so I wanted to propose two things that I think, if we were really conscious of the genuine challenge of this technology, we'd address our attention to. The first is, it is not insignificant that the way that machine learning systems work is to focus not on you, which is the heart of our justice system, you and what you do, but people who are like you and what they do. That is absolutely a foundational challenge to our public law system, to our justice system, and I think it is not being reconciled and addressed at all, and all the dancing around about principles, I think, ignores it fundamentally. It's huge, and I wish we paid more attention to it. A second fundamental challenge is that the degree of aggregation and consolidation of data on individuals is, I think, an unprecedented taking of intangible assets. There's nothing else that has no value at source except for marginal privacy rights and is now the foundation of the most valuable companies in the world. And there are many angles on which you could challenge this, and I think the continued preoccupation with ethics principles and privacy and data protection ignores that there are challenges that could be made, I think, in equity under unjust enrichment challenges. There's a growing attention to trust law. I think it's a much more foundational challenge of ethics, unconscionable conduct and dealing. The sort of power asymmetry involved, I think, requires us to look at other angles. Intellectual property pays attention to every other intangible asset. Why are we not addressing data with the same rigour? Property law and takings. So I think there's really fertile ground in which you'd see, I think, much of the current debate as a small piece and a larger field. And another dream, if in the same way that we could articulate red lines, if the week after a conference like CPDP, instead of having a conference about the narrow angles of fairness, accountability and transparency, if we could spend time paying attention to those fundamental challenges of why is the heart of the justice system no longer about us but about everyone like us, and why is this data asymmetry perpetuated without fundamental challenge, that would be a real achievement.
Thank you very much, Julia. So for our last round of the panel, after which we will open the floor also for questions from the audience, I would like to concentrate, or I'd like to ask the panelists to concentrate on what can be done, which actions can be taken. And I'm in particular thinking of two things which are on the agenda for this year. So the Commission has announced to publish its white paper on artificial intelligence on the 19th of February. It has been confirmed multiple times and can be considered official by now. And as we learned yesterday at an event here in Brussels, the German presidency will run the EU in the second half of this year and is very keen to bring its knowledge and objectives, including those from the Data Ethics Commission, into the European field and to the European level. So the question is, what do you advise in terms of actions to the Commission and to the European legislator and policy actors on the one hand, but also, if you can, a bit more concrete. There are two data protection authorities at this table and a few more in the room. So what is the actions that the data protection authorities should take? And I'd like to ask Christiane first. And yeah, please.
Well, that's a difficult task. So first of all, I have no idea what will be in that white paper. I have no idea what the German presidency is going to put forward. But of course, I can say what we try to advise. First of all, I think it's important that we advise to look at the whole issue from a holistic perspective and to, use a multi-level governance scheme to tackle this. I don't think, it's all about just, having this big piece of ethics guidelines or this big piece of regulation. It's something which you need to tackle at all sorts of different levels. So it's about education, digital literacy of the population on the one hand, but on the other hand, also, including ethical values in the curricula of the technical courses at universities and elsewhere. So it's a lot about education. It's a lot about, discussing these problems in public, making people aware. There's a lot to be done at the technical level. So many of the problems we see could theoretically be solved at a technical level. So it's about the design which those technologies take. It's about, we can achieve privacy by design. You can achieve a lot by design if you only want to do it and if you have the mechanisms in place. It's about how the economy works. So we need to look at the economy, at shaping the economy in a way that also AI and data takes the direction we want them to take. And at the end of the day, it's of course also about law. It's about, having the rules in place that we can, if necessary, enforce in courts. So I think, by and large, the Data Ethics Commission saw, when it comes to artificial intelligence, three big building sites, if you like. So the one is, of course, which is always at the core of public attention, is, you may call it algorithmic oversight or whatever. So, how do you make sure you have a control over the systems, how to make sure, that these systems are not used in a way that inflict harm on the individual and society. And what we came up with in that context is what we call the criticality pyramid. So unfortunately, I don't have a slide with me, but the idea of this criticality pyramid is that, when we're talking about regulation, we should take a risk-based approach. So we shouldn't just say all AI systems, we shouldn't just say all algorithmic systems need regulation. There's a lot of algorithmic systems, a lot of AI schemes around that do not need regulation. Why don't they need regulation? Why don't they need specific oversight? It's because the risk that comes with their employment is not very high. So, but then there are other algorithmic systems like personal pricing, like insurance schemes, and so on and so forth. Algorithmic systems that decide about who gets a job, about who gets further professional training. These have the potential of making decisions about the lives of human beings. And so they have an enhanced criticality. Also algorithmic systems that may cause harm to life and health, of course, have a higher criticality. So the further up you get into that, in that criticality pyramid, the more, we may need additional mechanisms to make sure we know what these systems are doing, to make sure, that humans stay in control. And so it's a whole range of different measures which we advise legislators to adopt. So this ranges from particular minimum quality criteria standards to risk assessment schemes, transparency requirements, we believe that, you know, the further up you get in this criticality period, the more competences the authorities must have, also to look a little bit closer at what these algorithmic systems are doing, and if need be, to take action. And then there is, at the top of the pyramid, there's even a smallish red zone where we believe, you know, those algorithmic systems should simply be banned, so you shouldn't simply be allowed to use them. But this is a very small area, and we largely believe that it can be solved by way of different mechanisms of algorithmic oversight. So this is maybe at the core of what we recommend concerning those systems. Then, of course, we also look, so this is the ex-ante perspective. So how do we make sure no harm is caused? There's, of course, also the ex-post perspective, which is about what should happen if harm has been caused, and that is about liability for algorithmic systems. So this is also something we looked into. And there we also submit a number of recommendations concerning, you know, product liability, vicarious liability, and the like. At the end of the day, the way we would like to see it, but of course that's not for us to say, is that we have, you know, one horizontal instrument at EU level that is based on the risk-based approach, that is based on a criticality model, and that sets out at a horizontal level the basic principles of algorithmic oversight and potentially liability, even though this could also be separate. And then that there would be sectoral instruments, both at EU level and at national level, to implement that. But let me stress that those two building sites, like, you know, the oversight one that addresses, you know, how to prevent harm, and the liability one that looks at how to compensate harm, are not the only ones. And this is really important to me, because we tend to be fixated with those oversight mechanisms, with transparency and risk assessment and so on, and with liability. We also need to, and I've said that before and I'd like just to repeat it, we need to look at what the standards should be on the ground. Because if we don't formulate those standards on the ground, then there is nothing which all those authorities can really, you know, control or check or whatever. So we need to make sure that the rules on the ground work in each individual context, and that individuals are protected wherever they are, whether they shop online, whether they apply for a job, whether they have an insurance scheme. So individuals need protection in whatever context, and we have to discuss what that protection should look like. And this is then what needs to be really implemented by authorities and by courts. Yeah, and this is also, of course, the role of DPAs at the end of the day.
Thank you. And I hand over to Bertrand to ask whether he thinks that what Christiane just described would fit with the French strategy and could also fit into the European strategy, but also what CNIL as a data protection authority can do as concrete action.
Actually, I share a lot of what has been said about risk-based assessment, and I think, from what I know, it's a direction where towards the Commission is going, and I think it's a good way to contextualize. And it's even a better way because we are in the moment where we're doing that for GDPR, where with all the data protection impact assessment, where we want people with high risk, people processing data with high risk to do that process and to document and to reflect on what does that mean to process that data, to have that kind of purpose. And I think we have a basis there that we can build on to address other problems caused by algorithm. The problem with that is we're far from having companies and organisms and organizations that are mature on that, so they're just starting. And I think one of the goals that we need to have in the short term, in the next couple of years, is to have companies that know what they're doing, know that what they're processing, know that they are documenting that, they have internal safeguards such as DPOs and others, and so because this is how we can scale the regulation, and we can have something that is costly for organization but that will be effective. I also share the fact that we need to have the red lines that have been discussed, and I think it's one of the challenges that Europe should ask himself: do we need to put some red lines? And one of the discussions that we probably will have in the coming month is about in France we had in the 80s we created the bioethics commissions because of the in vitro I don't know, fecundation fertilization. So when you have in vitro babies, so we created this bioethics commission saying what do we think about that? So we need to do the same approach, I think, for AI. It's actually what's in the French strategy, where there will be a pilot phase of an ethics committee that is a lot like the German Data Ethics Commission that will focus on specific topics. For instance, there is something on conversational agents, where the questions would be, when I speak to a robot, should I always know that this is a robot? So try to answer that kind of question, which is the answer is not obvious. But as Christiane said, it's a very small zone where you want to put red lines, and I believe that the best way to achieve is really to build on this accountability. That it's not my preferred word, but the fact that we have internal processes within the companies, and we also have data protection authorities with powers, with people, to control that. But I think we will have some scale if everybody gets into the subject. And perhaps the last point that I would say about the Europe's plan is also have in mind some kind of level playing field, and we should not have a situation where we are in our market, in the European market, solutions that have all the ethical frameworks and GDPR and everything, and all the burden that may represent for technologists or for lawyers or for everyone, for European companies, and in the same market, solutions that have been developed without all that framework, and from other continents that enter this market and that are in competition with ethical solution where their competitors have access to a market, but they have trained all their image processing without consent, without everything, and they have been able to have a very performant algorithm, but that has not been developed in an ethical way, in a European-style ethical way, if I may say.
Thank you very much, Bertrand. Marc, could you give us a few examples of action that you would suggest?
So this is very much a U.S. perspective. I'm going to describe for you 3 cases that we've pursued. I hope they might give you some ideas, particularly for the DPAs and the advocates and the academics. We have no law of AI in the United States, but EPIC is actually trying to establish this law. So we began a couple of years ago by bringing a complaint to the U.S. Federal Trade Commission regarding a company that had established a new technique called the Universal Tennis Rating. Briefly, so imagine the high school champion of a small city wanting to play against tennis, the high school tennis champion of a large city. Presumably, the champion of the larger city is a better player, but it's actually difficult to measure that difference. So this company gathered together a lot of data from tennis tournaments, high school competitors, looked at the results, and assigned ratings to each one of the players and said, well, the young girl in the small city is 11.2 and the young girl in the large city is 11.8, and maybe an 11.8 should be playing against an 11.8. It's actually very clever, but here's the problem. The company's technique is secret, it's proprietary, and it can't be proven in the sense that if I'm the father of the girl whose the rating is 11.2 and she routinely beats the girl in the other city that's 11.8, I have the obvious question, how is this number assigned? I mean, if in most sports, we look at time, we look at height, we look at distance, we can easily talk in objective metrics about outcomes. But we were actually fascinated by the creation of a rating system that assigned to children a numeric score that the basis of which could not be explained, at least not publicly. And of course, coming back to chess, we do have in the chess world something called ELO, which is public, non-proprietary, and provable. And among chess players, you can say, oh, you gained 5 points for this reason. And everybody knew. I mean, there's no secret there. It's provable. So this was also why it was interesting. We went to the FTC and we said, this is an unfair and deceptive trade practice. That's our legal authority. You can't assign scores to people without telling them the basis. Now, the FTC hasn't yet ruled on our complaint, but we think it's a good one. We brought another similar complaint recently against an employment screening company called HireVue. What does HireVue do? Well, HireVue works like with a large firm. Maybe it's Walmart, maybe it's Cisco, and they say, well, we have an opening for, 100 cashiers and we have 10,000 applicants. Who should we talk to? And HireVue says, we will take your 10,000 applicants and we will bring that down to 500 or 300, and then you decide which of that group, that subset, you want. And HireVue says, okay, perfect, this is what we do. They have a sophisticated algorithm, which they say relies in part on an automated interview that assesses voice tonality, facial impression, face topography, and produces, once again, a score to rank the job applicants. And again, we say, what's up with that? That can't be right. The good news is, since we've also done the OECD work and we've done the universal guidelines work, this time when we come back to the FTC, we say not only is this unfair and deceptive, but you, the Federal Trade Commission, under a particular legal doctrine in the US called established business practice, should require companies to consider the OECD AI principles and the universal guidelines for AI as established business practice in the use of AI-based technique. You see what we're doing? We're trying to build into our legal system the norms that we've helped establish through global frameworks to give them enforceability. Because as I said, principles alone don't mean anything. They have to have legal force. And so we bring this new complaint to the FTC. One more case to tell you about. We're actually kind of proud because this one was recently resolved favorably. So we brought an open government lawsuit. Now we're in the realm of the Freedom of Information Act, challenging the U.S. National Security Commission on Artificial Intelligence. This is a high-level commission created within our Department of Defense, co-chaired by Eric Schmidt. Some of you may have heard of him. He has a small startup in Silicon Valley. And this commission is tasked with making AI policy for the United States. And they're, reputable academics and so forth. A lot of people, by the way, who want to sell their reputable academic to the federal government for contracts, but that's a different conference. And we have no objection, by the way, to the creation of the commission. What we had an objection to was that the commission had 211 secret briefings with intelligence community, with vendors, contractors, all these people. And they said, I think they said, we're somehow secret. We don't have to observe open record laws. We don't have to observe open meeting laws, which is actually a little bit surprising for a government commission funded by taxpayers tasked with developing government policies. So we actually sued the commission under the Open Records Law, and we said that you are, in fact, subject to the U.S. Freedom of Information Act. And in December this past year, we got a favorable ruling from a federal judge in Washington who agreed with us. The case is EPIC versus National Security Commission on AI, and said the commission is in fact subject to open records laws, and now they need to begin to disclose to us their meetings. So I think, we talk about the transparency of algorithms, to be sure we think that's very important, but I think we also need to think about the transparency of the policy-making process. I've genuinely been impressed. Here in the EU, France, Germany, Canada, Japan, South Korea, I think there's been a real effort to make these discussions inclusive and open, and I think that's vitally important. Last, just to share a little joke. So after years of Eric Schmidt reading my email, now having won this lawsuit, I get to read his email. So there it is.
Thank you. That's a good progress. So as the last intervention of the panel, I would like to ask Julia, and if I go back to the question, what should the EU do? The EU certainly has the ambition to become a tech exporter in terms of artificial intelligence, and on the other hand, it has a strong perspective on mitigating and limiting the risks. So would you have any advice how to turn into a successful tech exporter without giving up ethical values and fundamental rights?
I think some trade-offs are probably necessary. The 600-page Australian Competition and Consumer Commission report on digital platforms that was released last year with a very poor government response is a great model that I think had very useful prescriptions that only an entity like the European Commission could actually execute. And I think there are some important leads there. I guess on Australia, coming from a country that's literally on fire, a continent, you probably picked up that I'm a little restless to do things that aren't what we keep doing and that feel a bit distinctive. And I guess there's an obligation to assist our legislators and policymakers with more prescriptions. That's why I think red lines are very valuable, and it would be great to work towards better consensus so you don't get more self-cancelling noise in the recommendations made. I also think there's a real opportunity for demonstrators of effective governance and to stand up models of how you would do enforcement. Strategic litigation at the moment is the kind of one backstop, but I think we could do some more proactive measures around accountability and tools to rebalance power. I'm personally experimenting with how to better resource some of those demonstrators. I've got a project with quite a lot of philanthropic resourcing to really supercharge some of the efforts that I think are at the moment fairly academic into actual demonstrators to put up, for example, in the NHS models of how you would match existing regulation tools with something that looks like a regulation in the digital sector, and to really, I think, my biggest space of opportunity, but it's closing fast, is around government procurement of automated systems and machine learning, and actually using that as a place to take some of these, what is evidently what we need once systems are used, and put it into the rules around whether or not technology is actually acquired.
Well, thank you. And these are a few lines of action. So we still have a bit of time for questions. If you have a question, please stand up and walk to one of the microphones in the room. And as the bellman will appear any moment, please make sure that the question is a short question and not a co-presentation.
The question may be short, but maybe the answer is long. I don't know. I really like the panel. I really like the discussion we have been having here in front of us. But I was wondering whether we were not focusing on one little aspect, namely discrimination and personal rights, and ignoring many other things like, do AI really have benefits? And what is the effect of increasing automation that is enabled by AI? And so, for instance, a very simple question like, if a help desk that is now manned by people is replaced by an AI that is responding to us, is that good or is that bad? And similar discussions around deep fakes and how well, what's the panel's opinion on those aspects of AI and the impact on society and how to deal with that? Thank you.
Thank you, Jan Penk. And I think we take the second question right away.
Okay, thank you, Barbara Egel. I used to be a DPO, and much of what is academic doesn't help that much in the real world. And I was very often faced with questions related to the use of publicly available data. And that also ties in with an issue that you raised regarding ownership of personal data. So I would very much like to know your views on the use of publicly available data. Do we really give up all our rights when we publish our views, our opinions, or any other personal data? Thank you.
Thank you, Barbara. So any volunteers? Bertrand, could you say something on the use of publicly available data? I mean, we have, of course, a very big case of kind of publicly available data with the Clearview story, which hit the news very recently, but on a more general perspective.
Yeah, I think the basis of data protection in Europe and for the last 40 years in many countries is the principle of purpose and proportionality. And that does, and from my point of view, it's not because you're publishing something that you're allowing anyone to do anything with that. And I think the Clearview case that has been presented last week is one of typical case of where this is highly questionable about the reuse of public images in that case for other purposes. So, from my point of view, this is one of the specificities of GDPR and the European framework is to keep the rights to alive all the time. So there is no way that it's fundamental rights. It's not something that you can exchange or that you can not have anymore. And it's also why I would be cautious with the ideas of ownerships or anything that is look like a tradable good. And I think it's really important to go on that path where we are able to defend the rights of the people, whatever they do with that, and whatever anyone is doing with that. And we had a lot of issues of enforcement of data protection in the last 40 years. I think this changes with GDPR and the level of fines, but this is the real question that will come in the next 5 years is are we able to enforce that fundamental right, and whether the data is purely private or even public, but I don't wish it to be used in any way.
Thank you, Bertrand. And the first question was about negative effects beyond discrimination, and are we sure that there is benefits from using AI, and what do we expect from further automation? Who wants to speak to that one? Christiane, please.
Absolutely. I think this is one of the key questions to be raised. The reason why we focused on data protection is because that's the title of the panel. But of course, there's lots of other aspects. And definitely, I believe that we need to look at each technology and each, situation separately. So you can't say it's always good to use those technologies. You can't say it's always better to use, traditional or to have human beings performing these tasks and to use traditional technologies. And you can't say it's always bad. You have to look at the effects it has. And definitely the effect you're looking at can't be restricted to the economic aspect. So you need to look at what does it mean for people's emotions? What does it mean for human abilities? I mean, if nobody knows how to read a map in 10 years' time, then we may have a problem as a society. What does it mean for the way we communicate with each other? So you need to reflect on all these implications if you want to make an ethically founded decision about whether a particular technology is ethically defensible or not. That doesn't necessarily mean that the same, that this technology must not be employed from a legal point of view, but definitely from an ethical point of view, you need to take all these considerations into account. But there may equally be situations where it's more ethically sound to use the technology, in particular in areas, that are heavily influenced by human prejudice, where, you have obvious unfairness in particular decisions. It may be much more fair to use these technologies than to have traditional ways of running things.
Thank you. Marc?
Yeah, I'll make a few brief points. As I actually acknowledge in our book, there are big categories of AI that we didn't address. Autonomous weapons, people are very concerned about. Labor displacement, as you suggest, I think people are very concerned about. And I think those issues need to be addressed. An earlier question, which I thought was a very good question, concerned the identification of robots, of AIs, because we have these interactions now. We're actually pursuing that in a case where we're trying to establish a rule, which I think you have now in an EU regulation, that requires drones, for example, to broadcast identifying information about the drone. This is a very important principle, and the aim is to reduce the identification asymmetry that results in spaces where we interact with robots. They know who we are, but we don't know who they are, and I think this is very important. Finally, I just want to say a word about publicly available data. We have a great problem with this concept in the US. I don't think it's quite so difficult under the GDPR, because under the GDPR, all forms of data, however they're gathered, that contribute to the processing, are subject to the regulation, which is of course correct. I mean, you can observe someone's race, gender, or age. The fact that you can observe these things doesn't place that data beyond the realm of regulation. But unfortunately, in the US, many people make this argument, and it's reflected in legislative proposals. So companies will say, well, we don't have to worry about legislation because that data is publicly available. That's absolutely wrong. It makes almost no sense, in fact.
Thank you. Julia, you want to have a few seconds for the very last word of this panel?
A quick chip in on that second one, so completely agree with that. And it is quite a challenge around publicly available data. I think it gives an additional angle that we have been very slow to pick up on, which is about collective rights in data. Of course, publicly available data has the geography of where it is available. And I think this is particularly coming out in the smart city example, where there are claims that any data in a particular environment is available. And I think in the same way that it took 20 years to get any degree of maturity around traditional knowledge and genetic resources and the inherent right of the peoples that information was gathered from to be recognised and to have some degree of dispositive rights over what might be done with that information. I think we need something similar around collective rights in spaces and cities in particular, because there is no other community but the community that's there. And I think that there's a lot that we can learn from Indigenous data governance and data rights in that space. It's quite mature, and there are protocols now for recognising data, tagging it, and ensuring that that sort of collective interest can be addressed. So that seems to me like an additional complement to what is clearly otherwise contextual and needs to be given the attention of the individual's interests.
Thank you very much. So we have to reach the end of our time. It's a coffee break now, so there is a possibility to continue talking without microphones and video recording. And I would like to ask you all to join me in thanking the panelists for this really interesting discussion.